For oral argument this morning is the case of South Carolina Libertarian Party petitioner against the South Carolina State Election Commission, Marcy Andino, in her official capacity as Executive Director. Before the parties begin, let me say we have received a request for an amicus brief filing from the State Senate, Senator Martin, Chair of the Senate Judiciary Committee, and President Pro Tempore, Senator Corson, asking that they be allowed to submit an amicus brief by noon tomorrow. I have granted the petition, but let it be with the understanding that the court may rule today, and I think we're not restricted by any potential filing in that regard. And with that, counsel, you may proceed.
May it please the Court, my name is Lauren Martell, and I represent the Libertarian Party in this case.
Ms. Martell, I hate to interrupt you initially before you get started, if you will, but there's a very important question that I think needs to be addressed at the outset. Did your party's candidates, were they chosen by convention this year, or are they to be decided by primary?
Your Honor, my understanding is that the Libertarian Party had a convention in November, and they voted to have a primary in 2014 and to have by convention for 2016.
And did they do the primary, as a follow-up to Justice Beatty's question, did they do the primary in response to this act so they'd be in position to go another route or have the flexibility under the act for the 2016 cycle?
Your Honor, it is the Libertarian Party's position that Act 61 is not in effect.
Ms. Martell, you've been asked a real specific question, and we need to know.
My understanding is that
the presence of the act, the motivation and the reason why the Libertarian Party chose to go the primary route for this June to set itself up for the 2016 cycle.
In case the act became effective, yes. I believe that they have conventions regularly.
So if the act was not effective, the Libertarian Party would not have jumped through those hoops.
If the act was not effective, they wouldn't have to jump through those hoops. If the act was found effective at some date, not necessarily when the convention was, then if they hadn't jumped through those hoops, they wouldn't be on the primary ballot. So they erred on the side of caution.
Okay, so they're on the primary ballot, is that right?
No, they're not.
They're not.
Right. The reason why we brought this case today is that a letter...
Well, there's a further question.
Okay.
The question Justice Beatty asked you, and that is, have you gone ahead and nominated candidates? Because whether you were a primary organization or a convention organization, the time for candidates to file was March 15 through March 30th. And it would then be incumbent on the party to certify those candidates to the Election Commission, and they would either become candidates without primary, or they would be candidates in a primary. What did the Libertarian Party do this year?
My understanding is that the candidates in the contested cases attempted to file, and that their checks were not taken. That's what my understanding is. So they're not on the ballot.
No, you're not answering our question at all.
I'm sorry?
And maybe I'm not making myself clear, so let me be sure we understand factually where we are, because we've got some representations in the AG's brief about this, and I want to be sure we understand where we are.
Okay.
There aren't any contested matters with respect to the nomination of candidates unless it's nomination by convention. When March the 15th rolled around, what happened with respect to the Libertarian candidates? The AG represents, or Ms. Andino from the Election Commission represents, that a good many candidates have filed, both for the Libertarian Party, the Green Party, and other parties, traditional convention candidate type parties. And they have not paid a fee, which they don't have to do when they do it that way. Mm-hmm. And that those filings have been made with the Election Commission. Is that correct?
Your Honor, that is a factual issue, and what we filed right now is for the legal issues, and we haven't had an opportunity to do depositions. My understanding, and I'm not a Libertarian Party member, and I didn't attend the Libertarian Convention, so my understanding from the petitioner, the Libertarian Party, is that their candidates did attempt, and there is a contested race out of the northern part of the state, to file for primary, and that it was not accepted.
By whom?
By that particular county's state election.
Well, that's very
filing.
interesting, because the county convention method of accepting nominations has all been thrown out of the window by Act 61. The old convention section, it's one of the many that's amended in this act, does provide for both county conventions and state conventions. The new act does not set it up that way. They're all filed with the state election commission if they're going to be, whether they're convention or primary candidates.
That's correct.
Well, that is something you ought to know.
That is correct, and I do know that. And it's what it also, if Act 61 is valid, which again, it's the position of the Libertarian Party that it is not, and that the contingency of Act 61 has not been met, and despite the Shelby case, it could still be met, and that Section 5 of Shelby versus Holder was not deemed unconstitutional. In fact, Justice Roberts only specifically stated that Section 4B was unconstitutional, and they left in the Voting Rights Act of 1965, Section 2, and also Section 5.
This whole discussion is moot unless you all have candidates who filed in the primary.
Your Honor, the Libertarian Party has never filed in the primary before. Under the new...
That's what you're arguing about. You're saying this year you chose to use the primary method. Did you or did you not? If you did not choose to use the primary method, this whole discussion is moot.
No, yes, they did. They chose to use the primary method, and they sent it in a letter to the Election Commission in January of 2014.
You understand that they sent a letter indicating that they had taken a vote at their convention. We're going the next step now and asking you as their lawyer whether they continue to comply with the requirements that one would comply with to file as a candidate. And that is to file March 15 through March 30th, whether you're a primary candidate or a convention candidate. That is the time for filing.
Yes, Your Honor. I understand that those candidates did comply with that, and I also understand...
In which way? Did they file as convention candidates or primary candidates?
As primary candidates.
Well, that's something that is not in accord with what the State Election Commission has filed in their brief. And that's what causes me some confusion.
Ms. Martell, I'm very confused, dazed, if you will. The single question before this court that you've honed in on is the efficacy or not of Act 61. Is that right?
Yes.
And that appears to me to be the sole legal issue before us. Is that your understanding?
No, sir. The secondary issue...
I'm going to ask them, what is the issue if it's not the efficacy or not of Act 61?
Well, because we just need to know when Act 61 was officially effective.
Well, that's what I just asked you.
And then at that point, Your Honor, if it please the court, I would submit that it would be... The secondary question is whether or not the Libertarian Party had the extra hurdle under the new voting law.
No, there is no secondary question. The only question before us, as I see it, and I'm going to ask Mr. Jones this too, the only question before us is whether or not Act 61 is effective, or if it may become effective at some point in time in the future. Whatever the answer to that question is, if it's yes, then certain consequences obtain. If it's no, certain other consequences obtain. But you tell me what that there is another legal issue before us, and I'd like to know what that is.
Well, it's that if Act 61 is in effect, then the Libertarian Party has to, in a primary, put on the ballot, the Libertarian ballot, through the State Election Commission,
You're challenging
a referendum.
You're challenging Ms. Andini's ruling that she would not conduct a primary for the Libertarians. If you have to conduct one, then you,
Yes.
Because we say 61 is effective, then you say the secondary legal question is your request for a declaration that the Election Commission is required by law to conduct your primary, right?
Yes, Your Honor. Yes.
And of course, the gist of my questions and Justice Beatty's questions were directed towards whether or not it would make any difference if you haven't already taken the preliminary steps it would take. You've asked for a primary. She said no. We're going to find out how in the world she could do that. But there are other things that would continue to have to be done, both under the old law and the new law, if you're really going to use a primary to select your candidates.
Yes.
And what I was trying to determine, and I still don't understand where you are on this, is what has actually been done to comply with the filing requirements for a party that's going to have a primary method of selecting nominees. And you still haven't answered that to me. As best I can tell, some folks have filed, and in one case there's a contest. And I take it that it is in that case that the county did not accept the filings.
Correct.
Is that correct?
That's correct.
So let me just I don't want you to dodge me on this, Ms. Martell. I'm not trying to fuss with you.
And I would never try to do that intentionally.
But I take it there are plenty of other candidates that have filed as Libertarian candidates for statewide office who have filed with the Election Commission. Am I right or wrong about that?
You're correct about that.
And the way they have filed would suggest that they are convention nominees rather than primary nominees. Am I right?
Correct.
And so I take it that means that the convention must have at least made some move towards selecting them as convention nominees, and that's why they filed. Or that they will conduct a convention in which they do that.
Your Honor, I really can't answer that question because we haven't had any discovery on that factual issue, and of course I wasn't present there. So for me to actually try to answer that question with a factual basis I don't think.
And of course, this suit was filed on April 14th, and there's this business about having to print ballots by April 25th to get the absentee ballots. So here we are on April 24th, being the doctors. We got to fix whatever is going on here. And so, again, I hone in on the question, is the act effective or is it not? And you say it's not, they say it is. So that's what we got to decide.
Let me follow up to that. And no one's fussing with you. It's frustrating to get a case thrown at you, not time to digest it, and we're given a deadline as tomorrow, perhaps, don't know. So, and there may be some confusion up here as to what the issue is. So we're trying to work through this together, and please take it, Ms. Martell, no one's fussing at you.
That's fine.
I would like to look at, I think as I understand your reason why the act's ineffective. You suggest that they still, notwithstanding Shelby and the declaration that that part of subsection 4 was declared invalid, that the balance of the act remains valid, and so the state could seek preclearance in any event.
Yes.
Not as a function of a mandate by federal law.
As a voluntary preclearance.
Well, as a function of the state law, the General Assembly's language.
Yes, absolutely.
Well, let's try to flesh out what Shelby really meant and why only subsection 4. And I don't know the answer. I'm just thinking this thing through with you and the others, if they would like to comment on this. As I read the Voting Rights Act, and I have not studied it thoroughly, we've had time constraints, it talks about covered jurisdictions. That seems to be a term of art. And the covered jurisdictions are designated in section 4, the section that was declared unconstitutional in Shelby. But they left the procedure for those designated covered jurisdictions to gain preclearance.
Correct.
It struck me as perhaps they left section 5 open simply to allow Congress the ability to fix the formula problem.
That's the way I read it.
Well, then the question is, what authority remains in the Voting Rights Act as it's presently written? Is there a mechanism for a non-covered jurisdiction to voluntarily invoke Section 5 and gain pre-clearance approval?
Yes.
Could you cite me to the exact provision and language? We're having trouble finding it. I am.
Section, it's Section 14, I believe, of Act 61.
No, ma'am.
No. We're not asking about Act 61.
Oh, I thought you were asking what mechanism
Voting
our
Rights
state.
Act.
Yes. Okay.
What is the authority in the federal law that allows a jurisdiction other than a covered jurisdiction? We know the covered jurisdictions are out because of Shelby.
Correct.
So let's say California was not a covered jurisdiction. Could California say, you know, we want to jump on that bandwagon too? So we want to submit our election laws for pre-clearance to the Department of Justice. Is there a mechanism under the Voting Rights Act to allow that to happen?
I believe that it still is Section 5. That's our position.
That's what we're having trouble with.
Oh, Justice Roberts.
Section 5 of the
Yes.
Voting Rights Act?
Justice Roberts indicated in his decision, the decision on the unconstitutionality of 4B in no way affects the permanent nationwide
We
ban.
understand that. We're not talking about what the Supreme Court said in Shelby.
Okay.
We are asking you to, if you got it there.
I don't have it right at my
About the
fingertips,
guts
the exact
of the
language.
voting-
I just refer to the exact
Because
language.
if there's no legal authority, this is what I'm just thinking out loud with you and
Right.
the other side. If there's no legal authority for a non-covered jurisdiction to seek and obtain pre-clearance approval, then to me, the opinion of the Attorney General may have some efficacy in terms of impossibility. But if a non-covered jurisdiction can obtain pre-clearance approval under the Federal Voting Rights Act, then perhaps their argument is not valid.
Well, it's our position and in our brief that we cited to that act that apparently, based on Judge Roberts' final order in the case of Shelby versus Holder, and I apologize that I'm not specifically citing, but I don't have Act 5 right in front of me.
I don't know the answer either.
Right, I don't have that right in front of me, but I believe that his ruling speaks. I refer to his ruling on the clear language of the law.
Upon for your assertion that a non-covered jurisdiction may voluntarily file is the Shelby versus Holder majority opinion of Chief Justice Roberts.
Yes,
So
correct.
that's your authority for this proposition.
Yes, that's
You
correct.
don't find it there.
That's correct. And then also in our law, the way it's written now in the clear and unambiguous language of Act 61, specifically gives those two preclearances too, written a little differently,
Right,
but still written.
Yeah, what we're asking, Ms. Martell, is if it turns out that there's no ability for a non-covered jurisdiction to voluntarily submit its election laws for preclearance, then you would agree with us that that means that that section is impossible of performance, correct? You'd have to, would you not?
If in fact it is impossible, but we submit that it is possible, a letter could be sent
For the
today.
moment, for sake of argument, let's assume that it is impossible. What would be the basis for requiring then that the conditions be met still?
I believe that it should be sent back to the General Assembly who makes the laws and that they should re-ratify it subject to the Attorney General's opinion.
We can't make the General Assembly perform any act, Ms. Martell. But let me ask you something. There's an alternative method as opposed to simply preclearance under Section 5, right? It is a declaratory judgment action, right?
Correct, in the district court.
I mean, you know, the General Assembly could condition it, the effective date of any piece of legislation, on the occurrence of the rapture if they wanted to. They could, and, you know, although that may never happen, that would be the effective date. The impossibility doesn't have anything to do with it, does it?
Well, the danger that we run is that Section 2 of Shelby versus Holder is also still in effect and was not deemed unconstitutional.
Section 3C.
Right, which means that any person in the state of South Carolina could go to the district court and seek an opinion on this, which means that the federal government, it leaves it open for the federal government to go in. And at this point, if we took care of it.
I mean, Section 2 is there, and what you're seeking, and when I say what you're seeking, not necessarily what you're seeking, but someone who would want this or any other election legislation to be stricken for whatever reason, or challenged for whatever reason, could approach it by Section 2, could they not?
Yes, a person, certainly an individual under Section 2 of Shelby versus Holder could file with the district court.
And can have it enjoined from having this effectiveness can be enjoined as a result of Section 2, could it not?
There are multiple possibilities in that situation, in that scenario. We are left, I think, vulnerable with the way it's written right now.
I gather the question for me at this juncture is simply this. Under the new statute that you are complaining about, well, not
I don't
want to seem to think that you're going to be required to have a primary so that you can have a convention next year. Well, this thing that we are complaining about, talking about here, what would require us, or what would require the legislature, or what authority do we have to sever, if you will, that condition from this bill?
Your Honor, I think that you have the authority to interpret the law as it's written specifically with the intent of...
Is there a severability clause?
There is a severability clause.
Would it be something that we could utilize in this particular act?
It's possible.
Let me ask you one further question in a little bit different vein, Ms. Martell. What happens if we declare that this act is not yet effective? That's what you're asking us to do.
Yes.
Correct?
Yes.
That means that we go back to the law as it was without this act being in effect. Is that not correct?
That would be correct.
Which means that the whole misery we went through with how candidates file their statements of economic interest would be back on the table, would it not? We had a big contest about where candidates file their statements of economic interest. We now have a whole new group of candidates who have filed for primaries and some by convention. And they are all required to file statements of economic interest.
Yes.
And one of the things that Act 61 does is to make it very clear that they may do that electronically.
Yes.
And my guess is they've all done it that way. If we go back to the old law, then we go back to Anderson. And we have all those candidates, every single one of them. I don't bet there's a one of them that made a paper filing of their statement of economic interest with the county party or the chairman of the party or whatever the old law said and whatever Anderson said. So we are now going to re-erupt that entire controversy, correct?
That could be one of, yes.
All right. Thank you, ma'am.
And, Your Honor, I would just say that Act 61 was drafted in clear language and called the Equal Access to Ballot, and that is...
knocking everybody off the ballot because of the technical argument that you're making would show not provide much equal access to the ballot, would it?
Your Honor, I just believe that it would be interpreting the law the way it is written. And if I may just say, the most important thing is not the candidate filing, but the referendum.
If in fact, beef is the referendum.
No, it's the referendum. Well, that's the second. It's all important. I think it really is all important, and I wouldn't be here if I didn't think it was important. And I see my time has expired, so I don't want to take advantage of that. If anybody wants.
Well, you'll have some time in reply.
Okay. Thank you.
Thank you. Counsel?
Madam Chief Justice, may it please the Court. My name is Johanna Valenzuela, sitting with...
Ms. Valenzuela, I'm going to ask you to pull that microphone just slightly. There you go.
My name is Johanna Valenzuela. Sitting with me is Sonny Jones, and then the Solicitor General with the Attorney General's office, and we represent the respondents in this case.
You refer to him as Sonny as opposed to C. Havard?
That is correct. Mm-hmm. We actually had that exact discussion before while talking about the introductions. I had an outline, but I'm actually going to set that to the side because I want to go ahead and address the questions that were coming from the bench, and I'm just going to do it in order that they came. Justice Beatty, you You asked whether the Libertarian Party had chosen to go convention method or primary method, and I think I can add a little bit more information than Ms. Martell had available to her, and that is that the Libertarian Party did file a letter with the State Election Commission certifying their candidates as primary candidates. However,
certifying their candidates, say that again.
Certifying their candidates as primary candidates.
Is that the January letter?
No, sir. They filed another letter, I believe it was received April 7th or before April 7th, within the timeline. The problem is that the statute requires, Section 71340 requires that they also pay filing fees if they're running as primary candidates. And no payments were received from the candidates or the party by the...
These are rather substantial filing fees, are they not?
Yes, ma'am. I think
they are now used by the state because the state now conducts these primaries rather than that expense falling on the parties. Is that not correct?
That's right. And I think it was part of our brief, one of the exhibits, that the Libertarian Party itself would have to pay over $20,000 in filing fees in this case. And then if we looked at all the, I'm going to refer to them as third parties, referencing other than Democratic or Republican parties. But if all the third-party candidates had to have a primary, they would be paying over $50,000 in filing fees in order to put their name on the ballot. Whereas right now, under the convention method, they don't have to pay any filing fees at all. And so that just kind of goes to the point of...
So by them not having paid the filing fees, do you consider their candidates to have been, their nominees to have filed?
We do consider them to have filed as convention method candidates.
Convention method, not primary.
So they'll be on the ballot.
Yes, Your Honor. Yes, but not as primary candidates.
Right.
And then to further, I didn't know if I was interrupting you.
No, I mean I just I wanted to get ahead to the efficacy or not of Act 61, but you go ahead and say what you want to say, and I'll ask you that later.
I'm going to take you at your word at that, and just briefly reference that when we're asking the Libertarian Party what their position is, we can look at their brief that they filed with the court, and we can look at the actual relief that they requested. And they said that if you were to hold that Act number 61 is not in effect, then all the financial concerns go away, meaning they would not hold a primary for their candidates. And it's clear. And I have the different page numbers.
You're talking about the concerns that the Election Commission has with not having the resources to put it on.
They reference that, and the considerations of the financial resources to put it on has to do with putting on a primary that is not necessary, and that goes to the overall question of what Section 71130 actually requires. And Justice Plakonis, moving on to your question about the efficacy of Act number 61, and we can also cover...
How about, consider that your argument in light of Coleman v. Lewis, a 1936 case. You familiar with that case?
I am not familiar with that case, Your Honor.
Case, let me just read you a little excerpt from it. It says, where an act is clothed with all forms of law and complete in and of itself, it is fairly within the scope of legislative power to prescribe that it shall become operative only on the happening of some specified contingency. Such a statute lies dormant until called into active force by the existence of the conditions on which it is intended to operate.
And Your Honor,
be more clear than that.
And that is clear, and we don't challenge that the General Assembly can elect to add provisions to their acts.
And they did.
And they did in this case, Your Honor, that's right. And they did so before the Shelby County decision was issued, which was June 25th of 2013. And I'll point out that right now there's a bill pending before the House that involves voting laws, and it's noticeable that if you were to refer to that bill, to the draft of that bill, and I'm just going to reference it, House Bill 3198, the timing provision, the preclearance provision, is not included there. It says Section 12, this act takes effect upon approval by the governor. And this is noteworthy because the General Assembly is indicating right there that the...
Well, and it goes on to say exactly what they meant but didn't put in Act 61, which is that since preclearance is no longer required, they declare that pursuant to the other section that the act took effect upon 20-day expiration after the governor's approval, and therefore was effective July the 3rd of 2013. They say all that in the legislation you're talking about that hadn't passed yet, right?
Yes, Your Honor. I mean, that's the message that is
You
being
understand that would fix it. How about talk to us about why the contingency does not stand in the way of the effectiveness of the act at the present time?
And that is because Shelby County held Section 5 to be invalid. Therefore, the pre-clearance
Section 4.
4B.
I'm sorry, it held Section 4B unconstitutional, which resulted in Section 5 being invalid as applied to South Carolina, just to be more precise. And so, but to shorten it, it held
South
Section...
Carolina voluntarily then say, gosh, we don't like that. We love getting Department of Justice pre-clearance, so we're going to go up there anyway. Could they still do that or not under the federal law?
They would not do that, Your Honor, and that's a good point. Because
Could they?
Does the Federal Voting Rights Act authorize a non-covered jurisdiction, a non-covered designated jurisdiction, the ability to seek and obtain pre-clearance?
I don't know of a provision that requires that, and it would be shocking based on the language and the analysis in Shelby County.
Ms. Valenzuela, I don't know if you mean to continue to use the term required, but that's what the whole argument is Martell is making, trying to keep that contingency in there and operate it, is that a jurisdiction can voluntarily submit to pre-clearance. And the question that's being asked you is that given the ruling that 4B is no longer effective, and that is the section that defines who has to use the procedure set forth in Voting Rights Section 5 with respect to pre-clearance, if they're not a covered jurisdiction, is there any vehicle within the law, the Federal Voting Rights Act, for a state to voluntarily submit a election law for pre-clearance by the Justice Department?
Not that I know of.
Must there be a provision in the statute, too, that says a state must voluntarily send?
If there was a provision that said a state, well, there is a method to require some states to seek pre-clearance of their voting law still, and that is under Section 3C. Yes, Your Honor. Section 3C, and that's a separate court order is entered under 3C requiring those states to do that. South Carolina is not one of the states.
I gather my question, I didn't phrase it properly. My question is there anything to prevent a state, notwithstanding the Supreme Court's action in Shelby, from voluntarily sending or requesting pre-clearance?
I think we could always send in a request. I don't know what the receiving party would do at that point without Section 4B to rely on.
We don't know because that wasn't done here, correct?
That wasn't done here because it wasn't necessary, Your Honor.
Well, 4B is only an identifier. It was a formula for identifying the states that must submit pursuant to 5C. I mean, 5.
5's still in effect. 5 is still in effect.
Yes.
There's just no formula to determine who is subject to 5. That's the whole deal. Now, there's another stated contingency in this act, which is a declaratory judgment action. Has that been filed, or was that ever filed?
That has not been filed, Your Honor.
Does that second contingency also derive from the Federal Voting Rights Act as an alternative to pre-clearance?
It does, Your Honor.
Department of Justice.
It does, Your Honor. And we can look at voting laws prior to Act Number 61 to see that South Carolina, being subject to Section 5 for over 30 years, has always put this requirement in, basically mirroring the requirements of Section 5, and that's the only reason that it was put in this act to begin with. And I know you referenced that you had received our brief and looked at it, and we cited 2 cases there because this isn't the first court that has looked at this issue. Davis v. Perry, the Western District of Texas, and Byrd v. Sumter County Board of Education, which is the Middle District of Georgia, has looked at this as well. And both of those cases indicated that the state election law would be effective even without preclearance after the Shelby County decision. And we think, based on Section 5...
What was the analysis? How did they look at that, and what was the basis for that decision?
In Davis v. Perry, actually I'm going to start with in Byrd v. Sumter, That case involved a plaintiff challenging the district line. Some of the districts were overrepresented or underrepresented. In the meantime, the legislature of that state passed some bills that remedied the district line problems.
Am I correct then? I believe I've read those, but the basis was that since those decisions of district lines were drawn as a basis of the Section 5 pre-clearance standard, then they could still use it or could not use it. What was it?
There's two. So there's one where the court had actually issued a modification number under the pre-clearance provision, and the state, after Shelby County said that the court, after Shelby County said that the state could have come back and said, we're not going to follow your modification order because we don't have to, but that they had opted to do so, and so they were bound by that decision. In Byrd v. Sumter County, it was basically that the court was already ruling and had issued a ruling indicating that it wasn't acknowledging the bills that remedied the district line problems because that bill had not received preclearance. And what's important in the facts behind that is that the state had actually submitted those bills to the Department of Justice for preclearance and then decided to pull them back. So in both cases, you have states that have indicated that they were voluntarily presenting themselves for approval, and the court said even when you indicated that you wanted to submit yourself for approval, we're still holding that the voting laws are in effect without requiring preclearance because of Shelby County.
Excuse me. Let me give you a what if. What if Shelby County had never happened, okay?
Yes, Your Honor.
And, you know, the Justice Department does not exactly act with alacrity. I think we all know that. And let's say they had not pre-cleared it or given approval. And, of course, the Robert Cook bobblehead is telling me, is agreeing with me right now. But I know. And but what if it had never, you know, and it was still pending up there? Where would we be right now today?
We would be functioning under the laws pre-Act.
Pre-Act 61 law.
Yes, Your Honor. And that goes to, I think I might be skipping just to answer that, we do have a severability provision in Act number 61, and that's Section 13. And so if this court were to hold that the preclearance provision, the timing provision is invalid, we would sever that from the Act, and then we would default to Section 2710.
Of course, that's your position. Now, I don't know that severability works that way, but, you know, on effective dates. But as the Chief Justice points out, there is a whole cascade of horribles if this act is not in effect, is there not?
And that leads right to my next point, Your Honor, and that's that, first of all, elections have already been held under post-Act number 61 voting laws. We've had at least one special election involving a House seat in Lexington County, and we've had some county council seats and some sheriff.
In which county, the House seat?
It covered Orangeburg, Lexington, and I think there was one more, but I can't remember it right now. And in addition to us already hosting or having elections under those laws, right now 731 candidates have filed under the new laws, and Chief Justice Sol pointed this out earlier. The new law requires that new candidates file with the county or state election commission. Before Act number 61, candidates filed with their county party chairman. And so you're looking at 731 candidates who are now open to being challenged about their filing under the right law if you were to hold that Act number 61 is not in effect.
Well, let me ask you this. That, you know, the parade of horribles is an argument y'all make in aid of the concept that it would produce an absurd result to interpret the law as Ms. Martell asked us to interpret it with respect to the contingency provision. And if that is so, then it means all parts of the law are in effect. And we are then, if we say the law is in effect, we are left with a further duty of having to interpret 7-11-30, which is the convention nomination situation, which got us all tangled up in this issue to begin with. The Libertarians followed that. They interpreted that provision to mean that in November of last year, they had to vote in convention to switch from a convention method to a primary method only so they could tee up in a primary this question of retaining their convention method of nomination. What possible authority did Ms. Andini have to tell them that she was not going to conduct a primary because it cost too much money and was too much trouble?
I can't point to any authority that would allow her to say that, but I would like to provide...
Well, that's a pretty...
she's got no discretion, does she?
She's got no discretion whatsoever. If the law says that the primary is to be conducted, and if a party requests a primary, and if they've done what the statute requires in terms of getting a 3/4 vote of their total membership to have a primary, no matter what their motivation for that, what authority did the head of the executive director of the election commission have to tell them she wasn't going to follow the law because it was too expensive?
There was no authority that would allow her to deny...
Well, then what authority have we got up here now that they have followed through on that, and even more filed and not paid the filing fees? That's another question. It's going to be about whether their filing is valid. What authority does the election commission have right now to say, oh, well, we're going to accept them as filing, but we're going to declare them as convention filings? What in the law allows Ms. Andini to do that?
Well, Your Honor, the Section 701130 only applies to parties that currently nominate by primary
Well,
method.
that's what you say, and you say it only because it sure doesn't say that outright. It's very poorly drafted, and this again is the thing that just drives us to distraction up here, is we get these contests about these election statutes, and they don't say what they intend to say, and then we're supposed to fill in the blanks. This thing says that they are allowed to nominate by convention if there's a 3/4 vote of the total membership of the convention to use the convention nominating process. That's number one. That assumes they are somebody that has a convention. And number two, a majority of the voters in that party's next primary election. Those words you interpret to mean, oh, well, this whole thing just applies to parties that have already had a primary method of selection.
Yes,
right?
Yes, Your Honor.
And yet, section number 1, it seems to talk about people that use conventions because it says there's a 3/4 vote of the total membership of the convention. Now, are you telling me that people who already have a primary method of selection have to go to their party's convention and get a 3/4 vote and put it on their party's primary the next time?
It does envision the Republicans and Democratic Party.
No, these people have done everything that they're supposed to do to comply with the law.
Well, not to correct you, but they have not, because they have not filed the filing fees in this case, and so they have not.
Excuse me, but that's one reason for that is because Ms. Andino has said that they can't have a primary at all. So here's the deal. They voted in their convention in consonance with the dictates of the law. 3/4 of them voted to switch to the convention method, knowing that in order to get to the convention method, which they had already always used in 2016, they had, under their interpretation, which was a reasonable one, of this statute, to, in their next ensuing primary, which would have to be 2014, conduct a primary to put it on the ballot and to get a majority vote of those who voted in their primary. So they've done what they're supposed to do. I would assume that, the next problem is going to be they didn't pony up any money. But thus far they've done what they were supposed to do, have they not?
They have, other than paying the filing fees. But it's important to note that the Libertarian Party isn't before you asking you to order us to put their candidates on the ballot. You don't see that anywhere listed in their relief for the court. What they say is, if you hold the act, the first thing they want is for you to say that Act Number 61 isn't effective. They say do that, and the financial resource problem goes away, meaning they don't plan on having a primary this year without Act Number 61. And then the second thing they say is, now if you find that Act Number 61 is effective, then we want you to order the State Election Commission to put our question on the ballot under subsection 701130A2 so that we can have a convention method in 2016.
And that is the crux of the problem. Had Ms. Andino responded to the letter in January and said, okay, we'll put the referendum on the ballot, because, then we wouldn't be here, we wouldn't have the thorniest legal problem of the month, would we?
We would have a thornier issue, Your Honor, because at that point what we're indicating is that under Section 71130, all parties, even if they're newly certified, even if they've always voted convention method, we're now required to have a convention to put that question on the ballot, and none of those...
Pretty clearly what the law requires, it seems to me.
If the law requires that, Your Honor, then that means that all the other third-party candidates who did not request to put that question on the ballot now have to have a primary in 2014, which is impossible, and in 2016...
No, they have to have a primary in 2016.
If they don't put... But we're assuming that Section 71130 basically defaults all parties...
Their candidates this year are illegitimate.
Why would their candidates this year be illegitimate? I don't understand that argument at all. If they choose to just go ahead with their conventions like they always have, then they're simply not someone that wants to change what they're doing.
And then Section 71130 would not apply to them. We agree with that, and we're saying that the Libertarian Party is in that exact position.
No, sir. No, ma'am. They had a convention in which they voted by a 3/4 vote to have a primary. Period. They did that in November.
Based on the efficacy of Act 61, to put them on track.
So that they could revert to in 2016 to their convention method that they always have utilized.
But the statute doesn't require that they put that question on the ballot if they...
Well, that's what we got to decide.
Well,
that's why y'all are here today. So, with respect, that's your argument. And that's what frustrates us about the head of the Election Commission. Rather than either seek a declaratory judgment about this thing when there was a lot of time to spare, she simply arrogated to herself the authority to tell them not that... She said, there's an Attorney General's opinion, and it says you don't have to do this. And then she further said, it's too expensive. Well, what if a party wanted to go on and have a primary, period? Is it that you're going to have one for the Republicans and the Democrats, but not for one of the third parties because it's too expensive?
Absolutely not.
Well, then what in the world was the reason for sending out that letter saying it was too expensive for these people?
The context behind that letter is that the entire concern from the Libertarian Party, and there were a lot of discussions between the Libertarian Party and the Election Commission, was that even the Libertarian Party didn't want to have a primary method. They don't want to pay over $20,000 to have their candidates listed on the ballot, but that they felt like the statute required them to do that and required them to put the question on the ballot. And Ms. Sandino did not agree with their interpretation of the law and thought that it would be an unnecessary step. You brought up the timeline from Ms. Sandino and how she could have sought a declaratory judgment. And I think it's important for the court to be aware of the Libertarian Party's timeline as well. This law passed in July of last year, assuming that the severability clause applies. This law was effective in July of last year. And then in November, Ms. Sandino, in response to a question, asked the Attorney General's office for an opinion on what 71130 meant. 71130 was interpreted as not applying to the Libertarian Party. Still, no action from the Libertarian Party asking for any guidance. In January, they send this letter. Ms. Sandino replies, essentially, guys, what are you doing? We don't need to spend this money to do this. We already told you don't need to put this question on the ballot to ensure your right to a convention method in 2016. And then months pass without them doing anything. They don't pay filing fees. The filing deadline ends. And then in April, weeks before we have to send ballots to our overseas citizens and military members, that's when they file something with the court asking for clarification of the statute. So I'm not saying that the Election Commission maybe we could have phrased our letter a little bit more artfully, but certainly the Libertarian Party could have acted as well in a way that didn't put us in the position that we are today.
Madam Chief Justice, may I ask a question? I would say going forward, one thing would be to respond to a letter sooner. I don't know why it took so long for the commission to respond to the letter, but that's beside the point. Ms. Valenzuela, at the outset of your remarks, you stated that the Libertarian Party has filed as a primary party this year, but they hadn't paid the fees.
Yes, Your Honor.
So when a voter in June of this year goes into the ballot box to vote and they look at the ballot, is there going to be a place for voters to make a selection in a primary for Libertarian candidates?
There is not. The process right now includes...
So they're not?
As it stands right now...
And that's because they didn't pay the filing fee?
Correct, Your Honor.
And the ballots are going out tomorrow and also sent to the troops tomorrow?
Yes, Your Honor.
And there's no option for the Libertarians, correct?
Well, you're saying that the option for the Libertarians, as I understand it, is they don't have to do that their nominees will appear on the general election ballot as a Libertarian Party nominee. That's what you're saying, right?
Yes.
And so they don't need to do that to be nominated. Now, I guess that works for everybody that's non-contested. Ms. Martell contends that there is at least one contested race. Do you know about that?
It is, and I don't remember the House district number off the top of my head, but it is. If you can give me a moment, I can look at it.
What are y'all going to do about that one?
It's our position that they can nominate those candidates by convention method.
So they could, in a subsequent convention, nominate. When would they have to send those nominations to you?
I'm not very specific, but I'm pretty sure that I'm not definite, but I can look that up and get back to you. But if I recall correctly,
so you're saying there's
it's
an
June 10th.
opportunity for the contested seat to produce a nominee by convention?
Yes.
Before the general election? Before
I think it needs to be done before June 10th, which is when the primary is held.
Right, because that is when the other parties will put forth their nominees.
Yes, ma'am. Yes, Your Honor.
I want to go back to Justice Beatty's question a long time ago. If there is no Libertarian candidate on the primary ballot, why is this not a moot case?
We think it is a moot issue. We think that 7-1130 is effective, and we think that it doesn't apply to the Libertarian Party. The Libertarian Party can go forward with their election the same way that they would have any other time, and in addition, they don't have to take any additional steps in order to be convention method in 2016. And so there is a good resolution to this. The thorn in this is that there were a couple of references to the Libertarian Party wanting to run as primary in 2014, and that does create an issue. But as we've discussed today, they haven't paid filing fees, so therefore they haven't finalized the process. They haven't asked...
Filing fees rejected?
I know that Ms. Martell suggested that was the case, but I had discussions with the Election Commission, and to our knowledge, there were no fees ever even offered by candidates or by parties.
Got two more bobbleheads in the audience saying that they, in fact, were, done, and there's a lot of head nodding going on in this case.
Well, I'm not going to do anything but pay attention to your argument, Ms. Buckley. That's all any of us can do.
May I ask a question?
Certainly.
Act number 3198, which has not been passed, bill number.
Oh, yes, ma'am. Yes, Your Honor.
What would be the impact that it would have on this case if it were passed this session?
I think it would clarify that Section 7-1130 is only meant to apply to parties that currently nominate their candidates by primary method, but wish to switch to convention method to nominate their candidates. And I know that I'm out of time. I could make a point about why the General Assembly wanted to make that statute only apply to primary method parties.
Certainly.
Okay. And so if we look at the context of the time when Act number 61 was passed, a couple of years prior to that, we had a decision, Greenville Party Republicans, that Judge Childs issued.
About the open primaries, that's the Judge Childs decision.
Yes, I'm glad that you're familiar with it. The entire challenge was to the open primary system. And in her discussion, and part of what she relied on was that the state had other methods of nominating candidates, such as the convention method. Going back and looking at how easy it was to switch from a open primary system to convention, all you have to do is get your convention to vote 3/4. We believe that the people who wanted to defend the long history of an open primary in our state, felt that it needed to be a little bit harder. There needed to be a little bit more notice before a party could shut down access, to voting in open primaries for that party and switch over to convention method. And that's why this statute is meant to apply only to parties that currently nominate by primary method and want to switch to convention method, because they want to protect the open primary system that's been a long history in our state.
That's not the way it reads, but in a nutshell, your argument is the act is effective and the fix for the Libertarian Party is to call an emergency convention right now and nominate this one contested thing, retract their previous vote, and nominate in this one contested primary situation and nominate that person by convention. Is that it? That's the total?
That's the relief that we want.
And everybody's happy?
We would submit that is the case.
Notwithstanding that there's, might not comport with the law. I understand.
Let me ask one final question about House 3198 that seeks a legislative fix to this issue of effective date and contingency. Has that legislation just been introduced, or do you know anything about whether it meets the May 1st deadline of having been passed and sent to the Senate?
I have the history in front of me, and the last thing that I see is April 16th, roll call, 36 ayes and 1 nay.
On second reading?
Read second time on April 16th, yes, ma'am.
All right,
yes,
so
Your
it's
Honor.
still in the House.
Senate. 36 to 1.
Oh, that's
I'm
third,
sorry.
Third reading as well?
All I see is read second time, Senate Journal.
They'll do that on Friday. So that's already, well, I'm just talking, don't pay attention.
I definitely defer to your knowledge on the procedure of this, but it does
I
say...
just want to know where it is now. It's got to pass over the bar by May 1st in order to avoid having to have a 2/3 vote to pass. And you're saying it's still in the House, but it's had the crucial second reading, which is the more important reading in the House.
In the Senate, it had the second reading, and it had a vote, according to the Senate Journal, in the Senate. And that it says Senate beside
It would have to be
it.
the Senate if it was 36 to 1, yeah.
Senate, it
So
says...
it is over in the Senate and has already had a first reading?
It says Senate, read second time, Senate Journal, and then Senate...
It's had a second reading.
According to this, on April 16th, it was read a second time in the Senate.
We see a lot of bobbleheads now.
Yeah. It'd be helpful if y'all would just file that stuff with us. You're asking us to jump through a lot of hoops here and rule very quickly, and some of this stuff's fairly crucial to us being able to do that.
Would you like a copy of the...
We got a copy of it. I just wanted to know where it was legislatively and whether it was close to passage. I think what you're telling me is that it is.
The last discussion that we had informally was that it was, and we think that matches up with the current legislative history.
And I'm certain if it's not, when you get back, you're going to tell them to move it along.
I hope everyone is listening. Thank you.
Thank you, Ms. Valenzuela. Ms. Martell, in reply?
Your Honor, all of these issues are difficult, and the ripple effect of the law of unintended consequences is often some things that are unforeseeable, but we do have to deal with. We are a nation and a state of laws, not personalities, and I submit that the Libertarian Party has erred on the side of following the law at every juncture in their petition. The right to vote, the right to run as a candidate is a fundamental right, and the ripple effect of this decision will have a huge impact on how we handle ourselves, whether we are a nation of following laws and abiding by what the law says, whether we like it or not.
Pardon me to interrupt
Yes.
you again. Having said that we're a nation of law, well, the law requires a filing fee for these candidates. Filing
Yes.
fees supposedly have not been paid. At least that's the argument by the commission.
Yes.
And your position is that you paid some.
Your Honor, my position is that I was not present at any of the filings. I understand that the candidates can file affidavits, and if discovery is required on that, they will. My understanding is that the candidates who were following what they believed needed to happen as far as filing fees attempted to make those filing fees, and that it was not accepted. So our position would be, yes, the filing fees were paid. The checks were just not cashed.
Can we assume, just for sake of discussion at this point in time,
Yes.
that the filing fees were not offered? would there be any room for argument now? Would you be on the ballot? Do you have an argument to require that you be given a primary if the filing fees were not paid?
Well, if filing fees are a prerequisite to getting on the ballot, then that issue may not make it to the primary ballot. But the more important issue is the referendum, which maintains the Libertarian Party's right to nominate by convention.
Ms. Martell, you know, maybe we should have had a mediation on this case, because it seems to me that what they're saying is that the act is effective, that there's only one really slight problem. The Libertarian Party's big concern is they want to continue to nominate their candidates by convention. That was the sole and exclusive reason that they sought to comply with the law, and they have done everything that they should have done to comply with the law. And they wanted to continue that without the inconvenience of this ballot question in 2014, so that they could revert back to their previous convention method of doing it. So what Ms. Valenzuela is trying to give you on our mediation is this opportunity to reconvene your convention and have one nominee done by convention, and then everything's over. Everybody's happy. It's hunky-dory. There's no problems, and we can go on about our business. Do you understand that's what she's trying to do?
Well, I understand that that's an offer before the court today, but the Libertarian Party has operated filing everything that they were supposed to do, and there would certainly be some hardship to them, and I can't put a price tag on that, and I can't put a value on that. I believe that their position is that they're at an extra step.
They won't care.
No, they will care. They will. I believe my client would care.
Ms. Martell, Justice Beatty asked you a question about filing fees. You answered in the context of individuals in one single contested race. I want you to answer the question in the context of the Libertarian Party's obligation to pay filing fees.
My understanding is that they would pay those. They've operated.
Have they offered and been refused?
I actually do not know the specific answers that on a certain date that they offered to pay the $20,000 or $50,000. My understanding, based on the way they have operated to date, is that they've been upfront and transparent and have followed the law.
They being
the Libertarian Party.
Libertarian Party.
Yes.
Has any mandamus action been brought against the commission to accept the Libertarians' offer to pay that filing fee?
I'm unaware of it, but that doesn't mean that it's not being done.
Thank you, Madam Chief.
Thank you, Ms. Martell. If you'd like to sum up, we'd be glad to hear you.
Well, I just have one quick little thing to say.
Sure.
I'd like to thank all of you for this experience today and this opportunity to put this oral argument before you. And I just rely on the brief and the law. And I came up here because I believe that the equal access to ballot is for all parties, and that I think that this court, even if it's very difficult and very hard, will do the right thing, and I appreciate it. Thank you.
Thank you, Ms. Martell. Court will be in recess.